Hello, dear aspirants. Welcome to Epitome IAS. So, dear students, we are doing the UPSC PYQ analysis. Today's topic would be Judiciary, part 4 of this particular topic. We'll be starting with the first question. Consider the following statements. 1. Justice V.R. Krishna Iyer was the Chief Justice of India. Statement 2. Justice V.R. Krishna Iyer is considered as one of the progenitors of the public interest litigation PIL in Indian judiciary system. Okay, so if you know about this particular person, Justice V.R. Krishna Iyer, okay, maybe this one of the difficult question here. So what we can say is this particular statement, first statement, is a wrong statement. Why? Because he served as a judge of a Supreme Court, but he never served as the Chief Justice of the Supreme Court of India. Obviously, you can't remember all the names, right? So just remember this thing. Then statement 2 is Justice V.R. Krishna Iyer is considered as one of the progenitors, that is the, we can say, pioneer of a public interest litigation in Indian judicial system. Yes, this is true. He is one of the pioneer of the public interest litigation, along with one other person, that is P.N. Bakavati. So these two people, he is also a justice. So these two people are responsible for the integration of the legal provisions related to the public interest litigations in 1980s, around 1980s. Okay, so what would be the correct answer? Option 2 is statement 2 is correct, so the correct answer would be B. Only 2 is the correct answer. So next question, how many high courts in India have jurisdiction over more than one state? And here union territories are not included. Try to answer this question first. Okay, what they are asking is how many high courts in India which have more than one state, which are which has the jurisdiction of more than one state. But here you should not include the union territories, only the states. So tell me the correct answer. So the correct answer would be 3. Option B is the correct answer. Okay. So what are these 3 high courts? Let's say we have a Bombay High Court. So Bombay High Court, it has jurisdiction over Maharashtra and Goa. Okay, so it is more than one state. Okay, it has 2 states. Plus it also covers the union territories of Dayu and Daman and Dadra Nagar Haveli. Okay, so all these, one is Maharashtra, other state is Goa, and these are the union territories. So these are, Bombay High Court has the jurisdiction of all these things. And what is another one? This is Bombay High Court. Then we have second one, that is Guwahati High Court. So Guwahati High Court has the jurisdiction over Assam, Nagaland, Mizoram, and Arunachal Pradesh. So if you can see here, it is more than one state. It is covering actually 1, 2, 3, 4 states. Okay, this is Guwahati High Court. Then the third one we have the Punjab and Haryana High Court. So it covers actually Punjab, Haryana, and Chandigarh. Chandigarh is a union territory. Okay, so it covers 2 states, more than one state, 2 states, and 1 union territory. Okay, so these are the 3 high courts which are having the jurisdiction of more than one states. And here we are not considering the union territory. So in the first case, Bombay High Court, 2 states, Maharashtra and Goa. Then Guwahati High Court, it is more than more than one state, Assam, Nagaland, Mizoram, and Arunachal Pradesh. And in this case also Punjab and Haryana High Court, it covers both Punjab and Haryana. So more than one state. Okay, it is covering more than one state. And apart from that, it is also covering some of the union territories. So if you want, you can take a screenshot of it. Okay. Then now tell me how many high courts are there in India currently. That is first question. And tell me including the union territories. Okay, now in this question we were talking about more than one state. Okay, but you should not include the union territory. Now I'm asking you, including the union territory, Tell me how many high courts in India have the jurisdiction of more than a state and a union territory. Okay, including a union territory. Okay, tell me. So the answer would be, first we have 25 high courts in India. Okay, and there are 6 high courts where we can say that it is having a jurisdiction over more than one state, including the union territories. Okay, it can include union territory also, not include union territory also. It is having more than jurisdiction of one state. Okay, the first three would be, already we saw those first three in the previous slide: Bombay High Court, Guwahati High Court, and Punjab and Haryana High Court. These are the first three. And there are another three. What are these? Let us see. So first we have, let us say first three we covered, right? The fourth one would be the Kolkata High Court. So the Kolkata High Court have the jurisdiction over the West Bengal and Andaman and Nicobar. So Andaman and Nicobar is a union territory here. So it is having a jurisdiction over one or more states and union territory. One is a state, the other one is a union territory. Then we have Kerala High Court. So the Kerala High Court has the jurisdiction over obviously the Kerala, and also which union territory? Tell me. The union territory of Lakshadweep. Okay, the union territory of Lakshadweep. Then we have the Madras High Court. So the Madras High Court has the jurisdiction over the Tamil Nadu and the union territory of Puducherry. Okay, so these are the 6 high courts which are having jurisdiction of more than a state plus another state or another union territory. Okay, so 6 high courts we have. And apart from that, which are the tell me which are the union territories which have high court for themselves, which are not sharing high courts from other states? So we can say we have Delhi High Court, which has its own high court. Okay, Delhi, which has its own high court, it is one of the union territory. And another one which does not share the high court. Tell me. That's it. Actually, Delhi is the only high court which does not share the high court, and it is the only union territory which does not, which has a own high court. Okay. Apart from that, we have, the Jammu and Kashmir High Court. Recently, due to the bifurcation, and these Jammu and Kashmir and Ladakh, they became the union territory. So now these two are sharing this particular high court. Okay, and this is present in Jammu and Kashmir. So okay, these are some of the facts which are related to the high courts in India. Total we have 25 high court. So you can see here the Bombay High Court, it has jurisdiction over Maharashtra, Goa, and union territories of Dadra, Nagar Haveli, and Daman and Diu. Okay. Then we have Guwahati High Court. It has jurisdiction over Assam, Nagaland, Mizoram, and Arunachal Pradesh. So this is the largest. It is having the largest number of states under its jurisdiction. That is the Guwahati High Court. Remember this also. They can make questions, right? So it is having jurisdiction over 4 states. Okay. Then we have Punjab and Haryana High Court, jurisdiction over the states of Punjab, Haryana, and the Union Territory of Chandigarh. Okay. Next question. Consider the following statements. Statement 1. The mode of removal of judge of an high court in India is same as the removal of judge of a Supreme Court. Okay. Statement 2. After retirement from the office, a permanent judge of an high court cannot plead or act in any court or before any authority in India. So what does statement 1 says? Statement 1 says that the removal procedure for a high court judge is same as the removal procedure of a Supreme Court judge. So this is a basic fact. We know that yes, the high court judges are removed in the same way. Okay, the process will be happening in the parliament even for the high court judge, not in the state legislature. Okay, so there will be impeachment process. So how much majority is needed? Absolute majority in both the houses, right? So the same procedure which is followed in the case of Supreme Court judge. The same procedure is followed for the High Court judge. So what they are saying here, the mode of removal for a judge of High Court in India is same as the mode of removal for Supreme Court of India, judges of Supreme Court of India. This is a correct statement. Statement 2. After retirement from the office, a permanent judge of a high court cannot plead or act. Tell me, what is this? What is the meaning of this plead or act? Plead or act, nothing but, let us say there is a high court judge. He got retired. Okay. Now after retirement, he can go and act as a lawyer in the same court. Okay, as an advocate. He can take up cases and he can advocate. Okay, this is what pleading or acting in simple terms I am telling you for your understanding. Okay, so what they are saying in this particular statement is, after retirement from the office, a permanent judge of a high court cannot plead or act in any court or before any authority. Is that true? So in case of India, no, that is not true. It is wrong. Why? Because let us say for the first 2 years, it is there that those retired judges of the High Court, they can plead in any court of India, any High Court or any Supreme Court, except those High Court which he was already serving. Okay, for the first 2 years. And after 2 years, he can plead in any court, including the court which he was already serving. Let me tell you again. For the first, there are two cases. First case is after retirement, like within 2 years. Within 2 years of the retirement, this particular high court judge who got retired, he can plead in any court of India, any high court or any other any Supreme Court or any other high court, except that court, that high court which he was already serving. Okay, then there is second case, second thing that will happen after 2 years of the retirement. After 2 years of the retirement, there is no restriction. Okay, now this particular high court judge, he can plead in any court, including those courts which he was already serving. Okay, after 2 years period. Okay, so this particular statement is a wrong statement. So option A, one only is the correct answer. Next question, assertion and reason. In India, every state has a high court in its territory. Reason, the Constitution of India provides for a high court in each state. So if you see here, just now we were talking about how many high courts we have. We have 25 high courts, and we saw like 3 cases where the high courts were shared between states. Okay, and 6 cases where the high courts are shared between the states and the union territories. Okay, what they are saying here in the first statement, in India, every state has a separate own high court for themselves. Is that true? This statement is a wrong statement because we saw 3 states which are actually does not have a high court of their own. They are sharing the high court from the another state. So this is a wrong statement. Then reason, what the reason they have given? The Constitution of India provides for a high court in each state. This is correct. Yes, the Constitution of India actually provided for the need for a each state should have a high court. But technically, due to other reasons, historical reasons and other geographical reasons, we do not have the high court for every state. Okay, that's why we are having only 25 states. Sorry, 25 high courts. So what we can say, option A, this assertion is wrong and reason is correct. So A is false, R is true, D is the correct answer. Okay. Consider the following statement. Statement 1. A person who has held office as a permanent judge of a high court cannot plead or act in any court or before any authority in India except the Supreme Court. Just now we saw this particular provision in one of the, I think, last question. Okay. Then, second statement, a person is not qualified for appointment as a judge of a high court in India unless he has for at least 5 years held a judicial office in a territory of India. So first let us talk about the first statement. Just now we discussed this particular thing, right? Tell me whether this particular statement is a correct statement or not. Okay, what they are saying here is any person, okay, after the retirement, after practicing as a permanent judge, he got retired. After the retirement, he cannot plead or act in any court or before any authority except the Supreme Court of India. Is this true? This is a wrong statement. Why? Because just now we saw he can plead, this retired judge, within 2 years, he can plead in any court, high courts, other high courts, and Supreme Court, except that court. Let's say this particular high court, Madras High Court, let's take an example, and this particular judge, he was working as a judge in the Madras High Court. After retirement, he can plead or act in any other high court. He can act in Andhra Pradesh High Court, Telangana High Court, okay, but he cannot plead in the Tamil Nadu High Court, that is the Madras High Court. Okay, he can plead in the Supreme Court as well. Okay, and before any authority also, there is no restriction. Only one restriction is there, that is he cannot plead in the own high court where he was serving before. Okay, after 2 years of his retirement, this particular restriction is also removed. He can plead in any court, any high court, Supreme Court, including the court which he was serving before. Okay, after 2 years. So here they are saying the retired high court judge, okay, permanent high court judge, after retirement, he cannot plead in any court except Supreme Court. Is that true? No, it's wrong. He can plead in any court, okay, including the Supreme Court, any other high court, except the court which he was serving before. That too for only 2 years. After 2 years, he can serve. He can plead in the same high court also. Okay. So this statement is a wrong statement. A person is not qualified for appointment as a judge of an high court in India unless he has for at least 5 years held a judicial office in the territory of India. So technically this is a wrong statement. Why? It is not 5 years, it is 10 years. A person for the appointment as a judge of an high court, he should hold a judicial office for at least 10 years and not 5 years. So this statement is wrong statement. Option D, neither one nor two is the correct answer. Okay. So according to Article 217 of the Indian Constitution of India, Indian Constitution, so the High Court judges, okay, a judge of an High Court is a person who must have either held a judicial office in India for at least how much? 10 years. At least 10 years he should hold a judicial office, okay, for the qualification. Then, or he must have been an advocate of High Court or any other, high courts in succession for at least 10 years. So either he can hold a judicial office for 10 years or he should have, been an advocate in the high court for 10 years. So 10 years in both the cases, it is 10 years. In the statement they have given 5 years. So that's why the statement was a wrong statement. Okay. This was clearly mentioned in Article 217, okay, of the Indian Constitution. So with that, we have come to the end of this video. We'll be seeing in the next class how we'll be trying and completing this particular topic. Thank you, students.